Start. In the instant case, comma, here the allegation was incorrect. Periods of experience mentioned in the certificates, full stop. This was sought to be explained by the petitioner through the information given, which has also been alleged in the writ petition, but the fact remains that the verification was carried out by the Medical Council of India and not by the central government, full stop. It is in this context that an opportunity by the Medical Council of India was necessary to be given for confronting the petitioner with the material that was to be used in this regard to withdraw the recommendation, full stop. The authority to recommend, in our opinion, also inherently, comma, in a matter for alleged misrepresentation or fraud, comma, possesses the power to withdraw the same, full stop. Such power deserves to be read to uphold the object and purpose of the function assigned to an expert body to recommend, comma, namely the Medical Council of India, full stop. We cannot be oblivious of the general principles of administrative law in an allegation of fraud or misrepresentation so as to denude the expert body of its power to withdraw recommendations or treat it to have become functus officio, even if such fraud and misrepresentation has been detected, full stop. If after such opportunity a finding would have been arrived at, comma, then in that event, comma, the endorsement on the declaration given by the petitioner dash college as extracted in paragraph 60 of the counter affidavit could have been pressed into service for withdrawal of recommendations, full stop. The endorsement ipso facto, without any opportunity to the petitioner by the Medical Council of India, would not operate adverse to the petitioner unless the said exercise is carried out, full stop. The petitioner no doubt had an obligation to make a correct declaration, but the petitioner should also have the opportunity to explain as to under what circumstances the certificates of the faculties had been tendered, believing it to be true, full stop. Collusion and fraud are not terms of ornament, full stop. They entail serious consequences, and in such matters, comma, where the penalty is harsh, comma, then the observance of the principles of natural justice becomes more necessary, full stop. It is for this additional reason as well that we endorse the ratio of the view taken by the full bench of the Delhi High Court to be attracted here in full stop para. To us, comma, it appears that the central government also overlooked this aspect of the matter while proceeding to communicate the decision impugned herein dated 29.2.2016, full stop. Consequently, comma, for all the reasons given herein above, comma, we find that an opportunity ought to have been given to the petitioner by the Medical Council of India before proceeding to withdraw the recommendation, full stop. That having not been done, comma, the recommendation was withdrawn in violation of principles of natural justice, and accordingly, comma, the said decision of the Medical Council of India dated 31.1.2016 deserves to be set aside full stop, since the very foundation of the withdrawal of permission of the central government rests on the withdrawal of the recommendation, consequently the order dated 29.2.2016 passed by the central government cannot be sustained full stop. Both the orders are hereby quashed full stop para. The writ petition is allowed to the aforesaid extent, with a clarification that quashing of the said orders would however automatically not amount to granting permission to the petitioner institute to take admissions in the concerned courses for which the orders have been passed full stop. Even otherwise, the schedule of the time for taking admissions and pursuing of courses cannot now be permitted in view of the apex court decisions cited on behalf of the respondents full stop. In the event the petitioner succeeds, it may be entitled to claim a fresh permission for running the courses in future and in order to avoid debarment full stop. Debarment. For the reasons aforesaid, the writ petition is allowed only to the aforesaid extent, leaving it open to the Medical Council of India to grant a hearing to the petitioner institute and pass fresh orders relating to the recommendations which it had proposed to withdraw full stop para. The prayer was accepted by the trial judge by order dated 19.4.2005 full stop as the basic objection as to the maintainability of the application no longer survives in view of the impleadment of the three sons of the defendant, the matters need to be heard afresh full stop. As noted above, the High Court noted that it had not gone into the merits of the case and except on the technical ground of non-impleadment of the three sons of the defendant, the application for temporary injunction was rejected full stop. In view of the changed circumstances, we remit the matter to the trial court to consider the matter afresh full stop. The effect of the impleadment of the three sons of the defendant, needless to say, shall be considered by the trial court full stop. The appeals are accordingly disposed of full stop. There will be no order as to costs full stop over.